NSA violations led judge to consider viability of surveillance program. Vertical line World News. Vertical line TheGuardian.com. Turn autoplay off. Turn autoplay on. Please activate cookies in order to turn autoplay off. Jump to content S. Jump to comments C. Jump to site navigation 0. Jump to search for terms and conditions 8. Edition, UK USO. Your activity. Email subscriptions. Account details. Linked services. Profile mobile. About us. About us. Australia team. Contact us. FAQs. Press office. Jobs. Terms of service. Privacy policy. Advertising guide. Guardian Weekly. Subscribe. How to subscribe. Guardian Weekly. Email services. Evony. Android. .gsc Control CSD width 25 rem exclamation point important. Padding 0. Float right. Input.gsc search button background color. Number sign PDDDD. Border color. Number sign PDDDD. Input.gsc search button hover background color. Number 999. Border color. Number 999. News. World. Sport. Comment. Culture. Business. Environment. Science. Travel. Technology. Life and style. Data. TV. Video. News. World news. NSA. NSA violations led judge to consider viability of surveillance program. Declassified documents from 2009 suggest NSA officials gave misleading statements to court and reveal judge placed a significant restriction the bulk records program. Share. Tweet this. Email. Spencer Ackerman in Washington. TheGuardian.com. Wednesday, September 11, 2013 08.20 AEST. Jump to comments. Judge Reggie Walton said thousands of American phone numbers had been improperly accessed by officials. Photograph. Brookscraft/Corbis. The judge on the secret surveillance court was so disturbed by the National Security Agency's repeated violations of privacy restrictions that he questioned the viability of its bulk collection of Americans' phone records, according to newly declassified surveillance documents. Judge Reggie Walton, now the presiding judge on the Foreign Intelligence Surveillance FISA court, imposed a significant and previously undisclosed restriction on the NSA's ability to access its bulk databases of phone records after finding that the agency repeatedly violated privacy protections. The documents, mostly from 2009 and declassified Tuesday, describe what Walton said were thousands of American phone numbers improperly accessed by government counterterrorism analysts. They also indicate that U.S. government officials, including NSA Director Keith Alexander, gave misleading statements to the court about how they carried out the surveillance. Despite repeated public assurances of NSA competence, the agency told the FISA court in 2009 that from a technical standpoint, there was no single person who had a complete understanding of its phone records architecture. All that led to daily violations for more than 2 years of call records from Americans not the subject of any FBI investigation and whose call detail information could not otherwise have been legally captured in bulk, Walton wrote. In 2009, Walton questioned whether the program could be allowed to continue, asking if the value of the program to the nation's security justifies the continued collection and retention of massive quantities of U.S. personal information. He considered the violations serious enough to order the authorities not to access the data collected until such a time as the government is able to restore the court's confidence that the government can and will comply with previously approved procedures for accessing such data. An internal government review launched in response to the order disclosed that in 2006, the NSA discovered one of its partner agencies its name is redacted by improperly included credit card numbers in its databases. Although the government said the problem only recurred once in 2008, it warned that to destroy records in the redacted that contain credit card numbers, NSA would have to destroy a swath of records in addition to those few containing credit card numbers. It pledged that under a future data management program, the fields containing credit card information will not be included in the data transfer and will be purged. Another document shows that the Justice Department told the court in January 2009 that the government had been querying the phone records database in a manner directly contrary to a court order and directly contrary to the sworn attestations of several executive branch officials. The documents, posted on a Tumblr recently established,